Gregory J. Cummings called me during the afternoon of March 9, 2011, insisting that DeShon is innocent and the judge on DeShon's case did not care about DeShon. In one of my responses to Gregory Cummings dated March 11, 2011, RE contract, do you know that there is also a charge of 1 count of possession of a firearm by a juvenile delinquent? I asked this question because up until March 9th, when Gregory Cummings called me, we discussed the cultivation of marijuana and murder charges. I also asked this question because I wanted to know if there were going to be additional fees for the extra charge against DeShon. After verbally hiring Gregory Cummings, we both agreed to meet at his Tallahassee office on March 12, 2011 to sign the contract and for me to give him money. Gregory Cummings and I signed the contract on March 12, 2011. One of the few things that I'd asked Gregory Cummings to do was to get access to DeShon's AT&T cell phone records. At the time, DeShon and I did not know that the Leon County Sheriff's Office had sealed DeShon's cell phone records. This is a copy of Leon County Sheriff Leslie Rayburn's cell phone record for DeShon's cell phone. This is not AT&T's document. The summary of offense and probable cause leading to DeShon being charged with the murders stated AT&T cell phone data had been obtained for DeShon Thomas's AT&T cell phone. This document is not AT&T's document. Leon County Sheriff Criminal Analyst Leslie Rayburn presented this map from MapQuest as to how she was able to locate cell towers for DeShon's cell phone. The summary of offense and probable cause affidavit leading to DeShon being charged with the murders stated AT&T cell phone data had been obtained in DeShon's cell phone. This is not a AT&T document. Here, Deputy Van reports, I continued to assist with scene security and maintained the entry log until released by VCU detectives. Detective McBride reports, the medical examiner, Dr. Anthony Clark, was notified and advised of this incident. He, Dr. Clark, was briefed on what information we observed and gathered. He, Dr. Clark, scheduled an autopsy for both subjects to begin at 0900 hours on January 28, 2011. Detective Dennis and crime scene detective Fred Smelt attended the autopsies. See their reports as well as the final autopsy report pending. Again, in part of securing the crime scene, Deputy Van started in entry control. According to the entry control log, no one from the District 2 Medical Examiner's Office arrived at the crime scene. This amended answer to demand for discovery filed April 4, 2011 is for the autopsy report authored by Dr. Anthony Clark in regards to Sterling Connor Jr. This document certifies that a true and correct copy of the foregoing has been furnished to Gregory J. Cummings. Then it lists Cummings' address signed by Assistant State Attorney Jack Campbell. This amended answer to demand for discovery filed April 6, 2011 is for the autopsy report authored by Dr. Anthony Clark in regards to Laqecia Herring. This document certifies that a true and correct copy of the foregoing has been furnished to Gregory J. Cummings. Then it lists Cummings' address signed by Assistant State Attorney Jack Campbell. Prior to signing the contract for service, Gregory Cummings promised to produce a copy of the victim's autopsy report to DeShon and I. As of July 16, 2012, over a year and a half after having signed the contract for service, Gregory Cummings had not produced a copy of the victim's autopsy reports. Neither had Gregory Cummings discussed with DeShon any information in regards to the deaths of the victims. In this email exchange between Gregory Cummings and myself, I'm fed up with Gregory Cummings' lack of work on DeShon's case. By now, it's obvious to me that Greg Cummings is deliberately working against DeShon instead of working for DeShon. I'm asking Gregory Cummings for a complete copy of Laqecia Herring's autopsy report and Sterling Connor Jr.'s autopsy report because Gregory Cummings had just sent me a few pages of Laqecia's autopsy report and nothing in regards to Sterling Connor. Also in this email, I'm asking Gregory Cummings about monies that may be refunded to me if I need to retain another attorney. At the time of this email exchange between Gregory Cummings and myself, I had paid Gregory Cummings nearly $30,000 $50,000. This was over 50% of the total fees and that he was charging me to represent DeShon. On July 16, 2012, Gregory Cummings emailed me 7 pages from Sterling Connor Jr.'s autopsy report. In Laqecia Herring's autopsy report, Dr. Anthony Clark notes in part post-mortem changes as rigor mortis is generalized and slight to moderate. In Sterling Connor Jr.'s autopsy report, Dr. Anthony Clark notes in part post-mortem change as rigor mortis is generalized and moderate to full. In an email exchange between Gregory J. Cummings and myself dated July 17, 2012, Gregory Cummings stated the following: I announced ready for trial today in court because I am ready, and anything else needed to be done by August 13th would be done. The judge asked that we talk to him sidebar. He has to have surgery for what appears to be cancer on his nose and is not available for trial. I talked to DeShon about it, and he was not happy, but he said he would be patient. So much to all involved, the state included, the case was continued until October 23rd. As you know, this is the 3rd time the trial has been continued, none at my request. As I told DeShon, there is very little the defense has control over. In another email exchange between Gregory J. Cummings and myself, Gregory J. Cummings states, TR Depo was to be taken today. I called his attorney last week to inquire if all was set. He got back to me Monday night and left only a message to call him, and I talked to him before court. However, on Tuesday I was told by his attorney he could not make it because of his work schedule and we would have to go there to depose him. His attorney does not want to make the trip because it would take an entire day and because I believe he will not get paid for it. So the depo was reset for August 10th here in Tallahassee with Jack Campbell going to talk to his parents and trying to convince them to him come up here. That was what I knew before court yesterday. Now that the case is set for October, I'm not sure what will happen. At the time of signing the contract for service, Gregory J. Cummings promised to produce a sworn deposition of the only witness who provided incriminating statements to have DeShon charged with the 2 murders. That witness was Trenton Ross. As of July 18, 2012, a year and a half after DeShon was charged with the murders, Gregory J. Cummings had not deposed Trenton Ross. On July 20, 2011, I filed a complaint against Gregory Cummings. I did not tell DeShon that I had filed a complaint against Gregory Cummings because, for one, all conversations in the Leon County Jail are recorded, and for two, I knew that Gregory Cummings' loyalty to State Prosecutor Jack Campbell would probably make things hard for DeShon. So I just sat on information and did not discuss it with DeShon. I filed the complaint with the Florida Bar. However, my other son and I did encourage DeShon to fire Cummings as his attorney. As for myself, I had stopped paying Gregory Cummings. Gregory Cummings' response to my Florida Bar complaint dated August 23, 2012. Gregory Cummings states that he has been in practice for over 32 years with a practice limited to criminal defense. Gregory Cummings states August 9, 2012, I received the complaint from the Florida Bar. DeShon had never mentioned it, and I still do not know if he knew that one had been filed. A motion to withdraw was filed as requested and granted on August 22, 2012, with the Office of the Public Defender being appointed. Ms. Chambers was made aware of this the same day. On August 16, 2012, Gregory J. Cummings filed a motion to withdraw due to conflict and appoint the Office of Public Defender. The motion to withdraw was filed with the Clerk of Court on August 16, 2012 at 10:52 a.m. Also on August 16, 2012, a summary of offense and probable cause affidavit was presented to Circuit Judge James C. Hankinson against DeShon Thomas, charging DeShon with solicitation to commit first-degree murder. The summary of offense and probable cause affidavit in part states that on Thursday, June 28, 2012, I received information from an anonymous complainant that I needed to speak with inmate Williams. I made contact with Williams that same day at approximately 3:45 in the unit of K-Pod. Williams advised he was currently housed with inmate DeShon Thomas, and the two have become close. Further, it states on July 12, 2012, I began monitoring jail calls from the Leon County Jail. Further, it states William describes the Facebook page to Thomas and he confirmed it was his personal page. Thomas said his brother and mother monitor his page and they will accept the friend request. It further states on July 9, 2012, Thomas called Williams. In the beginning of the call, Thomas tells him someone named Cole is going to be calling him. Further, it states on July 10, 2012, I received information from attorney John Kelly that he had a client who needed to speak to law enforcement urgently. He believed he had information that would save someone's life and it involved DeShon Thomas. Later that same day, I met with John Kelly and his client Walter Rayburn at the Leon County Jail. Rayburn was extremely nervous during the interview for fear of being viewed as a snitch. Rayburn stated he was a trustee at the Leon County Jail. Lastly, it states, at the end of the call, Thomas told Williams that he may receive a call from one of his crackers. His name is Cole, and they go way back. The summary of offense and probable cause affidavit charging DeShon with solicitation to commit first-degree murder was drafted and signed by State Attorney Investigator Jason Newland. A notarization of the summary of offense and probable cause affidavit was done on August 16, 2012. The order this cause coming before me as a first appearance magistrate and having reviewed the preceding affidavit, this court finds probable cause is sufficient. Signed by James C. Hankinson, Judge, on August 16, 2012. In the County Court, Leon County, Florida, State of Florida versus DeShon Thomas, defendant, complaint in the name and by the authority of the State of Florida before me. The undersigned authority personally appeared by Investigator Jason Newland, who first being duly sworn as that on the 28th day of June, A.D. 2012, in Leon County, Florida. The aforesaid defendant did unlawfully solicit another, DeJuan Williams, to commit first-degree murder, an offense prohibited by law, and in the course thereof commanded, encouraged, hired, or requested him to engage in specific conduct which would constitute such an offense or an attempt, including discussions about killing another human being, Trenton Ross, by use of a firearm, filed with the court on August 17, 2012. Also on August 16, 2012, a warrant for charges of solicitation to commit first-degree murder was given under Circuit Judge James C. Hankinson, seal. Hereby the sum of no bond, signed James C. Hankinson. On August 20th, 2012, Gregory Cummings sent me an email in part stating, FYI, as you may or may not know, DeShon was arrested last Friday for solicitation to commit murder of Trenton Ross. An inmate and fellow blood named Williams also has been arrested as the hitman. The state attorney told me that you are not a suspect in the offense. It further states DeShon can no longer have any phone contact or visitations with anyone other than his attorney. WCTV News posted online articles entitled Murder Suspect Accused of Trying to Arrange Hitman. The first article was posted on August 18, 2012, stating in part, January 2011, Herring boyfriend DeShon Thomas is accused of pulling the trigger. Now Thomas is accused of trying to arrange murder number 3 and have a key witness against him killed. A man accused of a Tallahassee double murder is now accused of trying to hire a hitman for one more. 19-year-old DeShon Thomas was indicted in March 2011 for the murders of Sterling Connor Jr. and Laqecia Herring in their Wolf Creek home earlier in the year. WCTV News reporters Lenitra Bennett and Julie Montanaro provided updates. Update, murder suspect accused of trying to arrange hitman. It will clearly have an impact on the murder case, Meg said. Further, the reporter stated, we talked to Thomas's lawyer to Greg Cummings, says he is disappointed and fears this will delay Thomas's trial. It is set for October 22nd. Cummings asked the court to remove him as defense attorney before Thomas was arrested on Friday. He cited an ongoing dispute between him and Thomas's mother. He says he was not aware of the new solicitation to commit murder charge until this morning. Order of appointment. This cause coming on to be heard upon the public defender's motion for appointment of conflict counsel. Is it ordered and adjudged the Office of Regional Counsel and Criminal Conflict Counsel, 1st Region, is hereby appointed to serve as counsel for the defendant. Done and ordered in Tallahassee, Florida, this 4th day of September 2012. James C. Hankinson, Circuit Court Judge. Notice of appearance. The Office of Criminal Conflict and Civil Regional Counsel, Region 1, enters its notice of appearance on behalf of the above named defendant, and all parties are called upon to take notice of the same. Certificate of service. I certify that a copy of this document has been furnished by hand delivery to the Office of the State Attorney this 26th day of September 2012. Office of Criminal Conflict and Civil Regional Counsel, Region 1, Samuel M. Olmstead, Assistant Regional Counsel. This docket report on case process for Thomas DeShon shows no action being conducted on DeShon's case between September 2012 and January 2013. On January 22, 2013, 19-year-old DeShon Thomas sent a letter filing pro se. A Ferretti hearing was set for February 19, 2013. On February 19, 2013, DeShon's attorney Samuel Olmstead with the Office of Criminal Conflict and Civil Regional Counsel did not show up to the hearing. The hearing was delayed for nearly half an hour, waiting on another attorney with the Office of Criminal Conflict and Civil Regional Counsel to appear in place of Assistant Regional Counsel Samuel Olmstead. The Assistant Regional Counsel announced that Samuel Olmstead was resigning from the Office of Criminal Conflict and Civil Regional Counsel effective March 1, 2013. Both the Assistant Regional Counsel and Circuit Judge James C. Hankinson assured DeShon that he, DeShon, would receive competent representation from the Office of the Criminal Conflict and Civil Regional Counsel's office now that Samuel Olmstead was resigning. DeShon believed that his new attorney could represent him at his scheduled March 2013 trial. DeShon withdrew his pro se motion and decided to continue to work with the Office of Criminal Conflict and Civil Regional Counsel's office. In DeShon's case, on March 1, 2013, a motion to continue went unopposed. On March 4, 2013, order granting continue case shall be continued from April 22nd trial docket and scheduled for case management on April 2nd, 2013. On March 4, 2013, case management conference set April 2nd, 2013. On March 20th, 2013, motion to withdraw due to conflict of interest dated March 19, 2013. Assistant Regional Counsel Director of the Tallahassee office had replaced Samuel Olmstead on DeShon's case and immediately filed a motion to withdraw due to conflict of interest. With DeShon not able to get an attorney to represent his best interests, DeShon filed a writ of habeas corpus. Noted here on March 26, 2013, letter, unconstitutional oath writ of habeas corpus supported by evidence, probable cause, pro se dated March 25, 2013. On March 27, 2013, order denying motion to withdraw due to conflict of interest. On April 2, 2013, order striking defendant's pro se pleading order and adjudged that the motion of a stricken as a nullity. On September 4, 2012, the Office of Regional Conflict Counsel was appointed to represent the defendant. The Office of Regional Counsel continues to represent the defendant. On April 3, 2013, notice of appearance, Regional Counsel Darren Shippey. On May 7, 2013, case comments from court events, waiver of speedy trial. On May 7, 2013, case management conference set June 4, 2013 at 8:30 a.m. May 7, 2013, case management conference set. Case management conference set to June 4, 2013. I had written Florida Governor Rick Scott on several occasions seeking a special prosecutor or some form of assistance with getting DeShon's case proceedings to move through the courts properly, to no avail. In this letter dated May 6, 2013, at this point DeShon had been in solitary confinement for about 9 months since the firing of Gregory Cummings. DeShon was not allowed to call home or have visitors. I had not seen my son in 9 months. In part, I state, must my son become mentally insane or die before my cries are heard? This is my third request asking and begging you to appoint a special prosecutor to my son's case. Listen, please, my son DeShon Richard Thomas is not a murderer. In this letter, I go on informing Governor Scott about Judge Hankinson. In the letter to Governor Scott, I state in part what I later learned was that several of Judge Hankinson's signed court orders assigning my son court-appointed attorneys had been withheld from the clerk of court, therefore being withheld from my son. Had my son and I had access to a court-appointed attorney before retaining Cummings, we may have never retained Cummings. I further state, I strongly believe that withholding the orders from the clerk of court was an intentional act of deception. I strongly believe this because on or before February 15, 2011, during the initial meeting with Cummings, I concluded the meeting telling Cummings that I was going to wait to speak with my son's court-appointed attorney before retaining a private attorney. Without any advance notice or motion being filed or a hearing, on June 2, 2013, judge assigned to case Judge Fulford Jackie. Circuit Judge Jackie Fulford abruptly replaced Circuit Judge James Hankinson. Circuit Judge Jackie Fulford made her debut on June 4, 2013, at which time a trial date was set for October 2013, pretrial hearing set for September 17, 2013, and pretrial hearing set for October 10, 2013. DeShon's case was going on nearly 3 years, and never had there been a pretrial hearing conducted. In a letter dated July 3, 2013, from Office of the Governor regarding my letter dated May 6, 2013, in part the letter states, although we appreciate your concerns, we are unable to locate previous correspondence from you regarding your son's criminal case. Governor Scott asked that I respond on his behalf. Here is a list of some, if not all, of the emails that I sent to Governor Rick Scott. I also mailed handwritten letters as well. Assistant Regional Counsel Darren Shippey filed a notice of hearing with the courts. The notice of hearing was set for August 19, 2013 at 9 a.m. Time allotted for 1.5. The notice was filed with the court on June 21, 2013. The purpose, defendants in limine motion to suppress evidence. Defendant's motion in limine Trenton Ross's drug use. Defendant's motion in limine someone else committed the offense. State's notice of similar fact evidence. I'm going to show a clip of the video from the hearing dated August 19, 2013. This video clip shows Leon County Sheriff Sergeant Gainey discussing the investigation of Ladidra Jenkins' Facebook threat against the female victim Laqecia Herring. Also, Sergeant Gainey tells about how the investigation centered along DeShon. Watch and listen. The defendant's motion in limine, someone else committed offenses, states in part, Ladidra Jenkins had motive to kill Laqecia Herring and took action to carry out that motive. 1. Ms. Jenkins had made threats on Facebook that she had a hit out on Ms. Herring. 2. Ms. Jenkins, along with others, confronted and threatened Ms. Herring with the intent to cause Ms. Herring serious bodily harm. 3. Ms. Jenkins was cussing Ms. Herring. All of the foregoing happened in close proximity of time to Ms. Herring and Connor's deaths, which occurred during the late evening hours of January 26, 2011, or the early morning hours of January 27, 2011.
Sergeant Gainey, did you have the opportunity to become involved in the investigation of the shooting deaths of Laqecia Herring and her brother back in January of 2011?
Yes, sir, I did.
At some point in time, did you become, I guess, the primary or lead investigator in the case?
I was the primary sergeant on the case.
As a result of being the primary sergeant of the case, did you become aware of a dispute that existed between Ladidra Jenkins and Laqecia Herring?
Yes, sir, I did.
Were you aware of a Facebook posting made by Ladidra Jenkins directed towards Ms. Herring that said, "I got a hit out for this bitch"?
Yes, sir.
Did you have the opportunity to either meet with Ms. Jenkins or conduct follow-up to that with respect to the posting and the dispute that existed between her and Ms. Herring?
The investigators, some of the other detectives, interviewed Ms. Jenkins, and with all the investigation and the leads that followed up, as far as the comments that were made, what the argument was about. As far as the investigation, we did not find anything to give credence to the fact that she may have committed this crime. It was all more of an argument, verbal argument between the two. She had made the comment, but there was nothing that we could substantiate that she carried anything out.
Right. And you were referring to Ms. Jenkins, right?
Yes, sir.
All right. Was Ms. Jenkins excluded as a suspect in this case?
As the investigation progressed, yes, sir. We didn't find anything we could substantiate. We couldn't put her at the scene. We couldn't put her in the area. All of the investigation that I say all of it, the investigation more centered along the defendant, DeShon Thomas, with statements and witness statements.
So if she was excluded, did I understand you correctly to say it would have been because you could not put her at the scene? What was the basis?
Defendant requests a hearing to proffer evidence and ruling by this court that such evidence is admissible and that the defendant may argue at trial that someone other than defendant committed the charged offenses, specifically Laqecia Jenkins or someone acting at the direction of Laqecia Jenkins. Wherefore, defendant seek relief consistent with this motion. This certificate of service signed by Darren L. Shippey, Assistant Regional Counsel, was furnished by hand delivery to Jack Campbell at the Office of the State Attorney on the 10th day of May 2013. Darren Shippey speaking about no-show in this video clip. Assistant Regional Counsel Darren Shippey tells Circuit Judge Jackie Fulford that Laqecia Jenkins did not show to court.
I think that's the...
Well, I guess there's one last argument the court will entertain it.
On which motion?
The motion that someone else committed the offense, Your Honor. If I can be heard on that.
You certainly may.
Your Honor, I took the time in setting forth in the motion the relevant case law. Law in Florida,
I've reviewed it.
okay, requires that if you're going to point the finger, and I'm speaking of the defense, point the finger at another individual specifically and say, hey, that's your person. The law in Florida requires that there be some clear link between the offense that was committed and the person whom you're blaming. I'm going to ask the court to find that clear link in this instance because, with all due respect, I called as two witnesses, the people that the discovery suggested to me had the most knowledge about the interactions with people connected with Ms. Jenkins, who's the person who made the threat, and Ms. Herring, who's one of the victims in the case.
May I interrupt and ask, do you have a copy of the interview of Ms. Jenkins? Was that audio recorded? Does anybody know?
Yes, I do have a copy, number one.
Okay.
I have listened to it, number two. The conversation that takes place with her does not talk about the threat. That came through LCSO's investigation.
Does the interview place her in one particular place or another at the time that the offense would have been committed?
Doesn't discuss it as I recall, which was one of the reasons for wanting officers on the record to say, what follow-up did you do to determine where Ms. Jenkins may have been during the late evening hours of January 26, 2011 or the early morning hours of January 27, 2011. I would respectfully suggest at this point in time that she has not been excluded, and what happened was Mr. Thomas's name popped up early in the conversation, if you will, and then they began focusing on him and his connection with Ms. Herring, the victim, and any thought of Ms. Jenkins being a potential suspect went out the window.
Here in Sergeant Gainey's report, Sergeant Gainey states in part, I along with Detective Odham had been shown the area of 2 apartments it could have been. Upon arrival at the parking lot, I observed a black female. I introduced myself to her and asked her if she lived there. When I asked her if she knew DeShon Thomas, her countenance changed. She stated she knew him and asked where he was. I explained to her that I knew he had left a gun at her apartment and I would like to have it. She went to her bedroom closet and retrieved a backpack and handed it to me. In the following video clip from the August 19, 2013 hearing, Sergeant Gainey states he did not have a search warrant to obtain possession of the gun. Watch and listen.
Inside the apartment?
Yes, sir.
And at that time, did you open the bag?
She handed it to me, and I believe we stepped outside. If memory serves me correct, we stepped outside to secure it as far as making it safe.
But in any event, in order to make the gun safe, did you open the bag?
Yes, sir.
Was the bag zipped closed?
Yes, sir.
Were you the person who unzipped it?
Yes, sir.
And as a result of unzipping it, did you open the bag, look inside?
Yes, sir.
And did you retrieve the firearm that you've described from within the bag?
Yes, sir.
Prior to seizing the gun from within the bag, did you have a warrant, a search warrant to do so?
No, sir.
On August 19, 2013, during the hearing, State Prosecutor Jack Campbell presented his witness, State Attorney Investigator Jason Newland, to address the state's notice of similar fact evidence in regards to DeShon having solicited DeJuan Williams to murder Trenton Ross. In the summary of offense and probable cause affidavit charging DeShon with solicitation to commit first-degree murder, State Attorney Investigator Jason Newland states, on Thursday, January 28, 2012, I received information from an anonymous complainant that I needed to speak with inmate Williams. I made contact with Williams that same day at approximately 3:45 in the unit of K-Pod. Williams advised that he was currently housed with inmate DeShon Thomas and the two have become close. In the next video clip from the August 19th hearing, State Attorney Jack Campbell tells of a different manner as to who prompted State Attorney Investigator Jason Newland to go to the Leon County Sheriff's Office to meet with Leon County Jail inmate DeJuan Williams. Watch and listen.
Whenever you're ready, Mr. Campbell.
Could you state your name for the record?
Jason Newland, Newlin.
And what do you do for a living?
I'm an investigator at the State Attorney's Office.
And are you currently assigned to working on the DeShon Thomas case?
Yes, sir, I am.
Did there come a part in time during the last year or 2 years that I requested you to investigate a plot to kill a witness, Trenton Ross?
Yes, there was.
DeShon Thomas was charged with solicitation to commit first-degree murder on August 16, 2012. State Prosecutor Jack Campbell's key witness against DeShon in the solicitation to commit first-degree murder case was Leon County Jail inmate DeJuan Williams. DeJuan Williams was not questioned about the interaction between him, Williams, and DeShon until October 7, 2013, nearly 14 months after DeShon was charged with solicitation. Leon County Jail inmate DeJuan Williams had been under the representation of Public Defender Nancy Daniels for more than a year. However, a week before DeShon was set to go on trial, State Prosecutor Jack Campbell made special provisions for his key witness, DeJuan Williams, to have a private attorney paid for by Florida taxpayers. State Prosecutor Jack Campbell selected a private attorney who was not registered to represent indigent defendants in this matter. The following video clip is from a pretrial hearing in DeShon's case dated October 7, 2013. Please watch and listen.
Did you have something, Ms. Daniels?
I have an interest in this hearing. that's
Oh,
coming
okay.
up,
That's fine. I just didn't know if I had something I wanted to cover.
maybe need to inform the court about it if asked.
Okay.
I can address that with Your Honor as well. Your Honor, on Thursday at 4:57 p.m. in the afternoon, I received an email from Ms. Daniels advising me that she planned to move to withdraw from representing DeJuan Williams. That's D-U-W-U-A-N Williams, who is a material witness in the solicitation to commit murder case. He's been subpoenaed by the defense, and if I had not, I'm assuming the state would have brought him in any event. for today's hearing, at Ms. Daniels' request, I went ahead and filed a motion to withdraw because the case would be coming to my office, delivered to your office Friday early afternoon, a motion to withdraw an order. I don't know if the court's had the opportunity to even receive the motion and order, but there was some concern about whether Mr. Williams would have representation, assuming he wanted any for the purpose of testifying in today's hearing. I think the state has gone above and beyond in making efforts, it looks like, to perhaps have somebody available on a interim basis. What Mr. Campbell and I have discussed is we've got some other things that we can take care of. Mr. Williams would likely be the fourth out of 5 witnesses that I plan to call today, so we can put him off for a little bit and then I guess address the issue more specifically when we get to his time to testify.
Just a second. Would you ask Deanna, DeJuan Williams, to see if there's a motion in order on DeJuan Williams in my office, please?
Your Honor, if I may, I believe Mr. Williams is in the courthouse at this time, and it would probably be best to go ahead and start moving the mechanics now on this issue. I don't want to continue next week's murder trial, but that's what we would be dealing with because of this conflict. I mean, that's the issue. I can't proceed without him, and if he decides to not testify because he's unrepresented, he's facing numerous serious charges at this point.
Yeah, I have my secretary trying to get the motion in order. You've already withdrawn.
Yes, Your Honor.
Okay.
I've talked to Mr. Alex Morris this weekend. I also talked to Mr. Ward. Both of them are on the Capital Conflict Council. Mr. Morris is scheduled to be in front of Judge Hankinson at 10:30 this morning, but he's told me that if I called him, he would certainly make himself available to the court, but I think it may require a special order for compensation for Mr. Morris to be able to, since it's a non-capital, to get him on there at this speed.
I don't know that. Do I have a right to just pick who the lawyer's going to be? I think the clerk has to assign them randomly or however, like in turn or something, don't they?
Your Honor, I know I've dealt with in cases before in extraordinary situations where where literally we've walked down the hallway and drafted. I've had judges order defense attorneys to do it, and that's what I'm basically going to be asking the court to do is to.
Well, I'm going to need Mr. Williams and Mr. Morris present for that.
Right,
So.
and that's what I'm going to ask for, and perhaps Ms. Daniels, because as far as compensation, my recommendation would be that because you're ordering them, either it'd be paid for either JQC, I think that's the right organization that normally pays them, or by Ms. Daniels' office for Mr. Morris's, because once again, we are dealing with an emergency situation where, a double homicide, it would frustrate a lot of our ability to proceed. So that's my recommendation, is if we do it that way, perhaps we can sidestep and make sure that both Mr. Morris is compensated for his work and that we have lawyers and we can proceed with, on this trial. I'll call Mr. Morris right now if we leave the floor.
Yeah, we need to get Mr. Williams. Do we know where he is? Yeah. Know where he's at?
Should be on the way upstairs.
Okay.
But in case he is, probably have to keep him somewhere out of area until we get ready to do it.
Okay.
Judge, there have been instances where in an emergency situation, a certain lawyer is available and the court can appoint him and we can work out that payment with the JAC. I don't think that'll be a problem.
Okay.
Could we approach, just
You
to
sure can.
give you a little more
Sure.
context here?
Sure.
Do you want me to get on this?
Yes.
On April 6, 2012, Tallahassee police received a report of a bank robbery at approximately 10:24 a.m. The victims were all of those at the SunTrust Bank located at 1401 Miccosukee Road. On May 23, 2012, the Leon County Sheriff's Office received a report of a bank robbery at approximately 8:38 a.m. The victims were all of those at the Farmers and Merchants Bank located on North Monroe Street. On May 23, 2012, the Leon County Sheriff's Office issued this release of public information announcing that deputies were investigating bank robbery, further stating that detectives have identified DeJuan N. Williams as a suspect. On May 30, 2012, the Tifton Gazette published an article entitled Tallahassee Fugitive Arrested in Tifton. A fugitive from Tallahassee, Florida was arrested Tuesday in Tifton by the U.S. Marshals Southeast Regional Fugitive Task Force with assistance from the Tifton County Sheriff's Office. DeJuan Nije Williams, 30, was arrested on charges of robbery and armed robbery in connection with 2 bank robberies in Tallahassee, Florida. Posted June 5, 2012, suspect connected to 2 Tallahassee bank robberies in Leon County Jail. This is yet another outstanding example of teamwork between several agencies to bring this suspect to justice, said TPD Chief Dennis Jones. I'm proud to be a part of the cooperative efforts to solve these crimes. Sheriff Larry Campbell said, thanks to the ongoing collaborative efforts to law enforcement in Tallahassee, Leon County, another violent suspect is off our streets. Docket report on case process for DeJuan Williams shows Williams being appointed a public defender on June 5, 2012. Also on June 5, 2012, bond amount set $15,000. On June 8, 2012, Williams entered a conditional plea of not guilty. On June 12, 2012, State Attorney assigned prosecuting attorney added Kappelman, Georgia. On June 22, 2012, State Attorney assigned prosecuting attorney added Ut Christie. On June 22, 2012, Notice 2 of Intent to Seek Enhanced Penalty Prisoner Release Reoffender Punishment Act. Prior to robbing the banks, Williams was already a convicted felon. The state, having filed a Notice to Seek Enhanced Penalty Prisoner Release Reoffender Punishment Act, is a type of mandatory minimum sentence for certain offenders previously released from prison. On June 28, 2012, bonded out. Bond date and time June 28, 2012 at 6:48 p.m. During State Attorney Willie Meggs' announcement to the public of DeShon being charged with solicitation to commit first-degree murder in August 2012, State Attorney Willie Meggs did not tell the public about the hired hitman being the armed robber of 2 Tallahassee banks, and that the violent bank robber had been out on bond 2 weeks after being brought back to Tallahassee. The following video clip will show State Attorney Investigator Jason Newland attest to the swiftness of DeJuan Williams being released soon after their first meeting on June 28, 2012. Please watch and listen.
And just for clarity, DeJuan Williams got out on bond at some point?
He got out on bond after our first meeting with him, within hours.
All right.
Over the next 6 months, Williams' case management conferences would constantly be reset. Williams, who had received money from both the Leon County Sheriff's Office and the State Attorney's Office for his cooperation with getting charges brought against DeShon Thomas, would remain a free man until he, Williams, got arrested in a neighboring county for armed home invasion robbery with kidnapping and a slew of other charges. The following 2 video clips are from an October 7, 2013 pretrial hearing in DeShon's case will show attorney Alex Morris put on the record that he is on the state's registry for capital cases, in which none of these cases are capital cases, and that he, Alex Morris, will not be in the state of Florida at the time in which he is needed during DeShon's trial. Yet, Circuit Judge Jackie Fulford proceeds to appoint Alex Morris as DeJuan Williams' attorney. Please watch and listen.
Did you know, do you want to take a break, Judge? I'm
I
fine.
do. Is that Mr. Morris? He is. Yes. Okay. Interrupt for just a moment and bring him in. You can stay right there. Morning, sir. What's your name?
DeJuan Williams, Miss Fulford.
All right, Mr. Williams, you're before the court in case 2013 CF 1136. You were previously appointed the Public Defender's Office to represent you. You're aware of that, of course?
Yes, Your Honor.
Okay, I have received a motion from them indicating that they have a conflict in their case, which means they can no longer represent you. Do you understand that?
Yes, Your Honor.
Has someone advised you of that previously?
Yes, Your Honor.
Okay. I'm going to grant their motion to withdraw. When I do that, I must automatically appoint the Regional Conflict Attorney's Office to represent you. That's the standard procedure. Do you understand that?
Yes, Your Honor.
However, at this point in time, they represent an individual in whose case you may be called as a witness to testify, so they automatically have a conflict as well. Do you understand that?
DeShon.
Okay, so they have filed a written motion to withdraw, and I'm going to grant their motion to withdraw as well, okay?
DeShon.
You're still entitled to have an attorney to represent you, however, and since the public defender was previously appointed, that means you qualify for the services of a public defender, an attorney provided at no charge to you. Do you understand that?
DeShon.
So I'm going to appoint another lawyer to represent you. Do you see the gentleman standing to your right?
Yes, sir.
That's attorney Alex Morris, and I'm going to appoint him to represent you. And his services will be paid for. That will be taken care of through the JAC or the Public Defender's Office. Mr. Morris will make sure that that's taken care of. Will you accept the appointment of this gentleman?
Yes, Judge.
Do you have any conflicts that you're aware of?
None that I'm aware of.
I'm going to give you an opportunity to speak to him now, Mr. Morris, if you have time, because whether or not we can proceed with this case to trial next week is dependent upon your ability to represent him and our ability to go forward based on that. So is there a place that Mr. Morris can meet with him? You want to do it in here, somewhere else? What?
Is the jury room available?
Any deals that you need to go ahead?
No, I'm taking care of it.
Okay.
Yes, we.
All right, very well. We're going to give you a place to meet with your new attorney, okay, sir?
DeShon.
All right, thank you.
Before Mr. Williams leaves, I wanted to advise the court of a discussion that Mr. Williams and I had. I leave for San Francisco for the Florida State mock trial tournament next Wednesday. In my discussions with Mr. Williams, he does not have any concern with my presence being here, and ordinarily, given the circumstances, because he's not a co-defendant or anything like that, I normally would not be present. We discussed that. He's fine with that. I do have an associate, though, that can potentially be here, and I'm going to notify him of that potential. But I just want to make sure that everybody's on the same page.
All right, you have any questions before that happens, Mr. Campbell?
Nope, that's fine. That's
Okay.
good.
Okay, thank you.
This Facebook post from DeShon Thomas's Facebook is dated November 27, 2010, 2 months before Laqecia Herring and Sterling Connor Jr.'s murders. DeShon had been in the Leon County Jail for more than a year and a half before he met Williams, it was in June 2012 as to when I began speaking with other attorneys about replacing Gregory Cummings. DeShon told me that Williams was introduced to him in the Leon County Jail and immediately became obsessed with wanting to murder Trenton Ross. DeShon did not believe him. Another inmate in the Leon County Jail named James Madison provided testimony about Williams' extreme interest in wanting to murder Trenton Ross. Williams began to teach DeShon how to read and write in gang code. 2 weeks later, after meeting with State Attorney Investigator Jason Newland, Williams was out of jail. The following video clips from a pretrial hearing dated October 7, 2013 will show James Madison providing testimony about Williams' interest with wanting to murder Trenton Ross. The other video clip will show State Attorney Investigator Jason Newland having called Williams to assist him, Newland, with the interpretation of a letter that he, Williams, wrote, showing how Williams was the main source for interpreting the letters for State Attorney Investigator Jason Newland, Leon County Sheriff Deputy Ronald O'Brien, and DeShon. Williams was the teacher and interpreter for all involved. Please watch and listen. James Madison.
What pod or pods were you in, if you recall?
I was in IJK.
During the time that you were in the I, J, or K pods, was Mr. Thomas ever also in one of those pods with you?
Yes, sir.
During that same time period, was DeJuan Williams in one of those pods with you?
Yes, sir.
Was there a time when the three of you, being you, Mr. Thomas, and Mr. Williams, were you all in the same pod at any time?
Yes, sir.
Do you remember what pod that was?
K-Pod.
If I asked you to tell me how long you think the three of you were in the K pod together, would you be able to tell me? And if so, what would that length of time be?
Yes, sir.
Pardon me?
Probably about, I got in K-Pod in January. The one came in out probably about, I want to say, he probably about no more than 2 months.
So
I don't understand what he's saying.
I'll ask it again, Your Honor. You think the three of you were in the K pod together for a time period of about 2 months?
Yes, sir.
And when you're in a pod, does everybody have their own individual room and bed, or if not, describe the situation and setting?
I mean, you got your own room, but you got a roommate, two-man cell.
Do you recall who your roommate was in the K-pod?
Yes, sir.
Who was it?
DeShon Thomas.
Are you able to recall who Mr. Thomas's roommate may have been during that time period?
No, sir.
All right. How about Mr. Williams?
He was in a room by himself.
He had one by himself?
Yes, sir. And he had a roommate. He just.
All right. During the time that the three of you were in the K-pod together, did you ever have the occasion to sit and talk with both Mr. Thomas and Mr. Williams at the same time?
Yes, sir.
Did the conversations that you had ever evolve into what the three of you were charged with, what you were facing, and things of that nature?
Yes, sir.
At any point in time, did the three of you discuss the charges that Mr. Thomas was facing?
Yes, sir.
Do you remember what charges he was facing at that time?
Yes, sir.
What were they?
2 M1s, murder 1.
Murder one? Okay.
Yes, sir.
Did Mr. Williams express any interest in your presence that you saw and heard in Mr. Thomas's case?
Yes, sir.
How would you describe the interest that he showed towards Mr. Thomas in his cases?
I mean, he was always like saying he was gonna help him out. You know, he ain't gotta worry about nothing. He gonna win trial. He gonna handle it for him. Ain't no problem. I mean, he was just always he was real adamant about it. He was always trying to make himself known. He was real forward with it.
What was the last thing you just
He
said?
was real forward with like.
Oh, very forward with it.
Yeah.
All right. Was that then apparent to you as you were sitting watching what was going on?
Yes, sir.
Did it seem to be out of the ordinary, perhaps compared to what other inmates may have shown interest in with other people in their cases?
In my opinion, yes, sir.
Please watch and listen. State Attorney Investigator Jason Newland. This.
And you got the letters?
Yes, ma'am. They're in evidence.
Okay, all right, go ahead.
Okay, and were they in code?
They were in code, yes.
And were you able to break the code?
Actually, the way we broke it two ways. We had the information, but did not know we had it in a code-breaking formula that we were provided prior. And then we called DeShon Williams, and I gave him 2 words that were written in this letter. And the 2 words that I gave him.
Thank you.
I asked him what FUVG would say, and he said that means shit. And then I gave him NYY, and he said that means all. Myself and Detective O'Brien and a few others at the Sheriff's Office wrote these on a board and wound up figuring out that's what they refer to as a high-low.
Is a copy of the envelope smuggled into the Leon County Jail containing a gang-coded letter from DeShon Williams to DeShon Thomas. The markings on the envelope have been copied to make the envelope seem as though the mail has been processed through the United States Postal Service as well as the Leon County Jail processing system. This letter to DeShon Thomas from DeShon Williams is written in gang code and was smuggled into the Leon County Jail by Leon County Sheriff's Deputy Ronald O'Brien. The following video clip will show Leon County Sheriff Deputy Ronald O'Brien casually testifying to having provided DeShon Williams, who was out on bond, with an envelope and stationery to write the letter to DeShon, and then Ronald O'Brien takes the letter into the Leon County Jail. Please watch and listen.
Say that again. It was a long way of saying, did you give Mr. Williams the envelope in order to mail the letter to Mr. Thomas?
Yes.
All right. Did you assist him with telling him the address of the Leon County Jail so that the letter could be delivered?
I believe so.
If that's reflected on the recorded, first of all, the drafting of the letter by Mr. Williams to Mr. Thomas, that's actually contained on a recorded interview, right?
Yes.
All right. And And did the sheriff's office then take the steps to have that letter that had been drafted by Mr. Williams delivered to Mr. Thomas?
I took it over to the Leon County Jail.
You yourself delivered it?
Yes.